Yep, great. Okay, well, thank you all for joining us. Welcome to the webinar on practical tips for communicating clearly and effectively in supporting vulnerable clients. My name is Richard Dickey Davis. I'm one of the founders of Tower Street Finance that are sponsoring this webinar. Please note the sort of the housekeeping points there in terms of asking a question. There's a Q&A facility, or there's a put your hand up in the raise your hand function. And then Helen will invite you to talk. And note, obviously, this webinar is being recorded. I was going to give you a little bit about Tower Street Finance. We are pioneers and market leaders in the new sector of probate lending, which has been going for about 2 or 3 years. It's basically allowing early access to proceeds of an inheritance for beneficiaries to access their inheritance either for whatever use they want, so buy a property or fund a challenge on a disputed inheritance, or for executors to fund either IHT loans or fund the other expenses they're responsible for when managing the estate. As you can see on the right hand side, that all these products come with no risk. There's no credit checks on individuals, no charge of a property, no estate shortfall risk, no return for a will, etc., etc. One of the things which is obviously pertinent for today's session is that all of our customers are potentially vulnerable, given they've just been through a bereavement. So we do have a link with Crew's Bereavement Care, where we can refer customers who are still suffering the effects of the recent bereavement. So that's a bit about us. So feel free to get in touch if you've got any questions on us. I'll now stop and I'll hand over to today's speaker, who is Holly Chantler of Moore & Co. She's partner and head of private client, also a panel deputy for the Office of the Public Guardian and the Code of Protection, and a director of the National Organisation SFE. Holly's also a registered STEP trust and state petitioner and a full member of STEP. She's got a long list of achievements. She was named one of the private clients top 35 under 35 practitioners in 2015-2016. She featured on BBC Radio 4's Money Box programme and co-authored the Elderly Client Handbook. She was also Surrey Law Society's Lawyer of the Year in 2021. And outside of work, she's done national competitions at eventing and show jumping. And now over to Holly.
Thanks, Dicky, and thank you everyone for joining today. I thought Dicky was just about to share our pre-meeting discussion around rugby and how we're both fanatical rugby fans, and we've managed to steer clear of that, because I do actually have something that I'm meant to be talking to you about, so hopefully you will find it useful. So I always get very embarrassed with people talking about who I am, so I'm not going to go, or what I've done, not going to go over that, but do feel free to contact me during the webinar or afterwards if you have any questions. The webinar will run for about 40 minutes, 40 to 45 minutes, and we'll have time for questions at the end. But say if you'd rather not raise them here, please feel free to email. Okay, so vulnerability is a really hot topic at the moment, with various reports having been published on the subject, including from the Legal Services Board, whose research highlights the need for the legal sector to provide better support to vulnerable customers. The FCA has also produced guidance which clarifies its expectations of firms on the fair treatment of vulnerable customers. So although it doesn't specifically relate to law firms, it is still relevant. And of course, the Law Society's guidance, which has been published, entitled Meeting the Needs of Vulnerable Clients, and which is going to be the basis of today's webinar. Okay, so today we've got quite a lot to cover, actually. Firstly, the professional obligations of practitioners. That's the scary stuff. We'll get that out of the way. Considering what is vulnerability, supported decision-making, capacity, undue influence, communication difficulties and what we mean by that, and some practical tips. So according to the Law Society guidance, there are 3 categories of vulnerable clients. The first one, clients who have capacity to make decisions and give you instructions, but need extra support to do this because of mental and/or physical disabilities. Secondly, clients who lack mental capacity to make decisions and provide you with instructions for whom you must follow a range of statutory and other safeguards. And thirdly, clients who are vulnerable to undue influence, undue pressure or duress, and who may or may not have capacity to make decisions and provide you with instructions. So as I said, I'm going to begin with the scary stuff and we'll get it out the way. And there's a theme that will be behind everything I say today. And if you've heard me speak before, it's a theme that comes up all the time, and that is about managing risk. And secondly, or perhaps it should be firstly, protecting yourself. Obviously, it's important to protect clients too, but managing risk and not getting yourself into a position where you could find yourself at professional or personal harm. You must, however, be wary about kicking the can down the road by saying you can't assist a client and making it someone else's problem or someone else's issue, because that person may not be as professional as you or have the same skills that you have, and therefore may not be properly safeguarded. There are procedures in place for protecting clients who are vulnerable, and it's important that you take ownership of that, but you do it in a way that protects you and the client. The mandatory principles which apply to all professionals regulated by the SRA, and failure to meet those professional duties may result in SRA sanctions or a referral to the solicitor's disciplinary tribunal. Failure to meet the needs of a vulnerable client could put you at risk of a discrimination claim or a claim for a failure to make reasonable adjustments under the Equality Act 2010, a claim for damages or compensation against you or your firm if you act on the instructions of a client lacking capacity, a complaint against you to the legal ombudsman, which could result in your name being published and or you having to pay financial compensation, a complaint to the SRA, and reputational risk. Legal practitioners must be satisfied that their client has capacity to give proper instructions. The obligation is supported by case law and the SRA's Code of Conduct for Solicitors, including Rule 3.4, which specifically requires solicitors to take account of your client's attributes, needs and circumstances, and Rule 3.1, which states you only act for clients on instructions from the client or from someone properly authorised to provide instructions on their behalf. If you do not have reason to suspect that the instructions represent your client's wishes, you do not act unless you have satisfied yourself that they do. Rule 8.1 requires you to identify who you are acting for in relation to any matter. And as I've already said, and really can't emphasise enough, failure to follow professional obligations may have significant consequences for you and your firm. It can be difficult where clients are not able to provide clear instructions for whatever reason, and it's the role of the practitioner to ascertain whether the client is capable of giving instructions, having taken all practicable steps to assist them to do so. Doubts may arise as to your client's capacity to provide instructions or the accuracy of those instructions for many reasons, including the client's circumstances, information you have been told in advance, who contacts you to arrange the meeting, and what the client says. So we'll look at capacity later on, but if you do need to obtain a capacity assessment, you should explain to your client the concerns you have regarding their capacity, the purpose of the capacity assessment, and any implications if they are found to not have capacity. You should obtain your client's written consent or express agreement to carry out the assessment and to instruct the capacity assessor. You should also advise them of any cost, and if you can, get money on account to pay for that. If you get a capacity assessment that says the person doesn't have capacity, you can often find yourself in a difficult position and with getting costs paid. You should take all reasonable steps to seek your client's consent for the capacity assessment to be carried out. If the client does not provide consent, you must explain to them in writing that you are unable to act for them, or alternatively you may, if you feel is appropriate, but it would be difficult to consider when this would be, continue to act without a report. If you do decide to do this, you must document your decision making clearly. You must also explain the potential consequences to the client, such as a subsequent challenge and the transaction being set aside by a court. If you consider that a potential client lacks capacity to give instructions, you may be entitled to decline to act from the outset. If you do wish to act, you should identify someone who has authority to provide instructions on behalf of the client, such as an attorney or deputy. If there isn't anyone able to act in this situation, you may consider opening a new matter for a court of protection application or referring the matter to another department. Obviously, you need to be aware of the risk of a conflict of interest depending on what you're being instructed to do. For an existing client, a retainer will usually automatically terminate upon loss of capacity unless there is express provision. Otherwise, that express provision would need to cover instructions being received from an authorised third party. So what can be really difficult is separating capacity from duress, coercive or controlling behaviour, as a client can have capacity, but it's difficult to identify this if they're being subjected to third party influence. If you suspect the latter and are not satisfied the client's instructions reflect their true wishes, you will need to decline to act. Okay. So I'm just going to go back on that slide, just slightly panicking, I've got different slides. Okay, so who is your client? So where your client has capacity, your client is your client, even if they're acting through an attorney. If they're being supported with whatever it is that they're doing, the letter of engagement should be addressed to and signed by the client and the attorneys as well. Sorry, it's an additional slide there. So where the client lacks capacity, the client is still the client and your duty of care is to them. So the letter of engagement should be addressed to and signed by the attorneys or the deputy, but the letter of engagement must make it clear that the client is the donor or P. And this also applies to archiving requests. Your duty of care is to the client. Attorneys and deputies act as agents only. The relationship between agent and principal, therefore between the attorney or deputy and the donor or P, carries with it fiduciary duties. If a deputy or attorney acts outside the authorisations of the deputyship order or the power of attorney, he or she is in breach of their duties and acts at personal risk as to costs. Okay, so looking at vulnerability. So the Law Society, as mentioned earlier, has identified three categories. So clients who have capacity to make decisions and provide instructions but require some additional support, clients who lack capacity to make decisions and provide instructions, and clients who are vulnerable to undue influence. Indicators of elevated vulnerability include age, physical disabilities, learning disabilities, brain injury, long-term alcohol or drug use, psychological or emotional factors, and developmental disability. And what I was really pleased to hear was Dickie in his introduction talking about vulnerability for clients who have recently been through a bereavement. So it's really, really important to recognise that anybody can become vulnerable at any time. Don't just assume that a younger person who's apparently fit and well and happy isn't vulnerable. You don't know what's going on. The FCA's recent financial lives research shows that 27.7 million adults in the UK, so well, I'd say almost every adult in the UK, now have characteristics of vulnerability, such as poor health, experiencing negative life events, low financial resilience, or low capability. So it's a massive, massive number. Again, don't assume that because someone doesn't fit into that box that they're not vulnerable. So not all people with these characteristics will suffer harm, but they may limit a person's ability to make reasonable decisions. You must identify your client's needs, and you should do this by ascertaining from your client whether they have any needs or preferences for communicating with you, need assistance to access services, need assistance for how services are provided, and are able to understand and action information and advice provided. So the second principle of the Mental Capacity Act, which is the framework looking at capacity, states that a person is not to be treated as unable to make a decision unless all practicable steps to help him to do so have been taken without success. This is a concept known as supported decision making. Over 3 million people in the UK live with conditions which can cause difficulties with decision making. Historically, individuals with impairments which affect their decision-making abilities would be considered to lack capacity. Luckily, we've moved on and the attitude is changing, particularly as a result of the UN Convention on the Rights of Persons with Disabilities, known as the CRPD, which has resulted in a number of jurisdictions introducing reforms to legal systems to ensure compliance. Interestingly, the MCA probably doesn't actually comply with Article 12 of the CRPD, and I think there are only about 3 countries in the world that do, but at least we're moving that way. Supported decision making is arguably a broader concept than Principle 2, which is why it's one of the reasons why it's perhaps not compliant, and it's more commonly understood and applied in other jurisdictions, particularly the US. It's very good at it. There's been increasing work done in this area, and the University of Birmingham's Everyday Decision Research Project is one such example, and you might want to look this up afterwards. So the report itself considers ways of supporting individuals with mental impairment to make a will. There have long been calls for the MCA Code of Practice to be updated to reflect the broader supported decision taking model, and it is now nearly 20 years old. So things have changed since then. And the government is actually due to publish its recommendations regarding amendments to the Code of Practice shortly. And I would expect it to make changes or suggest changes regarding supported decision making. For the time being, Chapter 3 of the MCA Code of Practice provides guidance regarding supporting others to make decisions. The guidance includes the following checkpoints. Providing relevant information. Does the person have all the relevant information they need to make a particular decision? If they have a choice, have they been given all the alternatives? Communicate in an appropriate way. Could information be explained or presented in a way that is easier for the person to understand? Have different methods of communication been explored if required, including non-verbal communication? And could anybody else help with that communication? Make the person feel at ease. Are there particular times of day when the person's understanding is better? Are there particular locations where they may feel more at ease? Could the decision be put off to see whether the person can make the decision at a later time when circumstances are right for them? And support the person. Can anyone else help or support the person to make choices or express a view? We'll come back to that later on. Guidance goes on to consider other factors, including how someone can be helped to make a decision, what information should be provided to people and how should it be provided, so what information is relevant, communication guidance and helping people with specific communication or cognitive problems, what steps should be taken to put a person at ease, timing, support from others, and other ways to enable decision making. Other factors to other factors to consider include the physical accessibility to and around your office. So how will the client actually access the building? If they're a wheelchair user, are the access ways big enough? Are there disabled toilet facilities? Can the client actually access the meeting room? The doors wide enough? Do the doors swing the right way? Are the tables in the right place? Or would it be more appropriate to see the client at home? Although remember that if you do so, it may not be appropriate to charge for it. It depends on whether the client is, simply speaking, making a choice to not come to the office, or whether because as a result of their disability, they're not able to. And if you see someone at home, remember that you may need to serve the appropriate notices under the consumer contracts regulations. Is the website easy to navigate and read? The font easily viewable? And ensure written communication is appropriate. So use simple language at all times, but consider whether other adaptations are needed, such as large font or different coloured paper. Okay, so looking at capacity. So what is capacity? It's the ability to be able to make a particular decision or action at the time the decision or action needs to be taken. This may include day-to-day decision making, as well as more significant decisions which may have legal consequences. Examples of more significant decisions include buying or selling property, making a gift, making a will, making a power of attorney, entering into a contract, conducting litigation, or dealing with divorce and financial separation. Individuals may lack capacity to make some decisions, but not others, on some occasions, but not others. So it might not only be in circumstances where you are concerned as to whether the client lacks capacity to provide instructions, where it may be appropriate for a capacity assessment to be obtained. So other situations include where a lasting power of attorney is being executed and it's likely to give rise to an objection, for example, where only one child is being appointed as an attorney. Having a specific capacity assessment from the time the LPA was executed, prepared by an expert specifically addressing the capacity to make an LPA, is likely to help mitigate any objection, including the time it takes to resolve and the cost of doing so. Secondly, where the client is making a will, which is likely to give rise to a claim. And a contemporaneous capacity assessment should help the effect of any claim, but it needs to be specific to what it is that's being done. Just a general client lacks capacity or has capacity isn't good enough. And then finally, another example around the golden rule. So the judgment of Mr. Justice Templeman and Kenwood and Adams, that, quote unquote, when a solicitor is drawing up a will for an aged testator or one who has been seriously ill, it should be witnessed or approved by a medical practitioner who ought to record his examination of the testator and his findings. Where a client is proposing to make a disposition which will significantly affect their estate and may give rise to claims either during lifetime or on death, and potentially archiving requests made by attorneys or deputies. Remember, the client is your client. Your duty of care is to your client. So if someone's ringing up and saying, I want this because I'm an attorney, they're not entitled to it as a matter of course. The person who assesses capacity will usually be the person concerned with the individual at the time the decision needs to be made. So it might be the person's spouse, partner, carer, health professional, or legal representative. If the decision to be made is serious or the outcome significant, a more formal approach may be required. And where there is doubt or a debate about capacity, it is ultimately a judicial decision. Where an expert assessor is required, it is necessary to determine the specific issue or issues for consideration to help identify who's the most appropriate person to conduct the capacity assessment. Examples include potentially a GP, but I'll come back to that, a psychiatrist, a geriatrician, a speech and language therapist, or a social worker. The general practitioners are often reluctant to prepare a capacity report, and in any case it's generally preferable for an expert capacity assessor to be instructed, because they are experts and general practitioners are general practitioners. Although this will likely result in a higher financial cost to the client for the report to be carried out, it will usually carry greater weight in any subsequent challenge, and it will provide greater protection to you as the practitioner. Sorry. When instructing the capacity assessor, the practitioner should provide clear instructions, which should include basic information about the client, including any health concerns and diagnoses, the nature and extent of the expertise required, the purpose of the report, the specific issue or issues for consideration, an explanation of the relevant legal tests, including the burden of proof, any timescales, and confirmation of costs. Okay, so coming back to the MCA. So as I said earlier, the current legal framework for assessing capacity and around capacity generally is the MCA. So it makes it clear that the definition of lack of capacity and the test of capacity are set out in the MCA are for the purposes of the Act. The Code of Practice states that the statutory definition of capacity is in line with common law tests, and the MCA does not replace them. There is some debate as to the extent that this is correct, particularly with the crossover between wills and the test set out under the MCA. But for the purposes of today, and probably for what you are doing in your day-to-day role, just assume that the MCA will apply. But all decisions made on behalf of, on respect of a person who lacks capacity, must be made pursuant to the principles of the MCA. And these are set out in section 1. So the principles are, firstly, that a person must be assumed to have capacity unless it is established that he lacks capacity. Secondly, as we've already covered, a person is not to be treated as unable to make a decision unless all practicable steps to help him to do so have been taken without success. Thirdly, an act done or decision made under the MCA for or on behalf of a person who lacks capacity must be done or made in his best interests. And finally, before the act is done or the decision is made, regard must be had as to whether the purpose for which it is needed can be as effectively achieved in a way that is less restrictive of the person's rights and freedom of action. So for the purposes of the MCA, there is a two-stage test of capacity. The first stage, is set out in section 2, states that a person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter because of an impairment of or a disturbance in the functioning of the mind or brain. Examples of an impairment or disturbance in the functioning of the mind or brain may include conditions associated with some forms of mental illness, dementia, significant learning disabilities, the long-term effects of brain damage, physical or medical conditions that cause confusion, drowsiness or loss of consciousness, delirium, concussion following a head injury, comes back to rugby, and the symptoms of alcohol or drug use. It does not matter whether the impairment or disturbance is permanent or temporary, and there does not need to have been any formal diagnosis. So it's time and matter specific. A lack of capacity, so there's a rogue capital C in there, cannot be established merely by reference to a person's age or appearance, or a condition of his or an aspect of his behaviour which might lead others to make unjustified assumptions about his capacity. Test of capacity is on balance of probabilities, so that is whether a person is more likely than not to lack capacity to make the decision in question. For the purposes of section 2, a person is unable to make a decision for himself if he is unable to understand the information relevant to the decision, retain that information, use or weigh that information as part of the process of making the decision, or communicate his decision, whether by talking, using sign language, or any other means. The fact that a person is able to retain the information relevant to a decision for a short period only does not prevent him from being regarded as able to make the decision in question. But depending on the question or the decision that needs to be made, if a person forgets very quickly and it needs to be repeatedly referenced to them because there's a series of decisions that need to be made, it can be difficult, and the person may be deemed to lack capacity because of that. But if it's a here and now decision the person then forgets, that doesn't preclude them from being able to make the decision in question. Section 3 requires the person to understand the information relevant to the decision, which includes information about the reasonably foreseeable consequences of deciding one way or another, or failing to make the decision at all. The relevant information depends on the decision in question and can be referenced, can be determined by reference to case law. So I've got a couple of slides setting out current case law for a few decisions which may be relevant to you, but presumably you'll be sent a copy of the slides so you can have them there. I'm not going to go into them. Okay. So if it is established that your client lacks capacity to provide instructions, you may be able to take instructions from a third party. So we don't have time to go into this today, but you're always welcome to contact me if you've got any specific questions about it. But as I've said on the slide, duty of care is to your client, always your client being the person who it ultimately relates to. Okay, so here are the tests that you might want to reference later on. So undue influence. As I said earlier, clients may have capacity to instruct you, but are not able to give clear instructions or proper instructions as a result of undue influence. It can be very difficult to identify where a client is being influenced or is the subject of coercive and controlling behaviour. Unfortunately, I can't give you a magic tool to be able to identify influence, but I would suggest you're always aware of it and look for warning signs such as the involvement of third parties, and those third parties attempting to give the instructions, speaking or answering on behalf of the client, or the client looking to the third party when responding, or where those instructions just don't add up. It's rather sad, but I treat everyone with suspicion, mainly because of the work that I do, but it's not always a bad position to take when considering undue influence and risk. There's a number of things that you can do to help mitigate undue influence, and the one that you must always try to adhere to is seeing the client away from family or friends. If the client needs support to provide instructions, consider whether there is a professional who is better placed to do this rather than a family member. If the client insists on the third party being present, you need to record this in your file note. If you're happy going ahead, if not, you'll need to decline to act, but never ever act if you do not believe, well, as I said, never ever act if you do not believe the client's instructions reflect their true wishes. Again, it can be really difficult to ascertain, even if the client is seen on their own, but at least if you do see them on their own, that's a starting point to being able to weed out some of that influence. As I've said several times already, all comes down to risk management. What is the client attempting to do? What are the ramifications, particularly if it goes wrong? And what is the risk to the client and to you? There are some circumstances where a presumption of undue influence automatically arises, such as a gift to a family member. You don't want to be caught up in litigation where the gift is overturned and you're not able to demonstrate that the client was properly advised in the absence of the benefiting party. So what do we mean by communication difficulties? It can be difficult to identify what a communication difficulty is, but it may be things such as difficulty speaking clearly, difficulty producing words and sentences, difficulty understanding what other people are saying, difficulty with reading, difficulty with writing, and difficulty understanding and using symbols. Examples of communication disorders include hearing or visual sensory impairments, developmental speech and language disorders, dysphonia, motor speech disorders, aphasia, cognitive communication disorder, and dysfluency. And any of those may or may not have a formal diagnosis. But again, just because someone does have a diagnosis, it doesn't necessarily mean they lack capacity or they can't give you instructions. And if they haven't got a diagnosis, but you think, well, they're struggling with reading, for example, again, it doesn't mean that they can't give you instructions or lack capacity. So the types of people who may experience difficulties, or situations where someone may experience difficulties, will be people with lifelong or chronic conditions, including autism, learning disability, traumatic brain injury, stroke, brain injury, brain tumour, progressive neurological diseases, dementia, mental health conditions, or people with temporary conditions, including delirium, effects of substance misuse, which can then lead to long-term impairment, medication effects, post-traumatic amnesia, fluctuations in mental health status. Communication difficulties can be a barrier to a person being able to provide instructions, indicate their wishes, feelings, beliefs and values, or make independent decisions. Okay. So before we consider a few practical steps to help support a client, I need to come back to the second principle of the MCA. A person is not to be treated as unable to make a decision unless all practicable steps to assist him to do so have been taken without success. And you as a practitioner need to demonstrate that you have done this. So a few practical tips to help you to support the client and to assess capacity if that's an issue, or just to help to support them to make a decision. So in the context of assessing capacity, I've got 5 key points. The first one, identify the decision to be made. Be really clear about it. Identify the legal test to be applied. So for example, if it is capacity to make an LPA, it's the Mental Capacity Act that applies. Consider what is relevant information. So what is relevant to being able to make a power of attorney? In one of the previous slides, I've set out the case law for it, but it's things like understanding that an attorney will be able to act on your behalf, having some idea about what your assets are, understanding who it is you're appointing, understanding that you can revoke their appointment. It's relevant information to the specific decision that needs to be made within the legal framework that applies. Fourthly, identify any additional support the client may need to be able to make that decision. We'll come back to that later on. And record the meeting fully, including the questions asked and the responses received. So before the meeting, you should consider the most appropriate time and place to meet the client. Might not be in the office. It might be in the office, but is the meeting room that you're suggesting the best one? Is it accessible? Is it light? Will it, are there any factors that mean the client's not able to stand the best chance of making a decision? Is it noisy? Whatever it may be. Does the person have any particular dietary arrangements? So something, that can be quite reassuring is offering someone a drink. Well, how will they actually be able to drink? If you're giving them a cup and saucer, is that going to be something that they can use, or would a mug be better? Might seem mundane, but it's ways of reassuring the client and making them feel at ease. Think about the language that you are going to use. It should always be simple, whatever it is, but it might be that you need to think of things in a slightly different way, particularly if somebody struggles with concepts or long words or legal terminology. Are there any tools which would help facilitate communication, such as a picture book, electronic translation tool, or an induction loop? Work with other professionals who may know the person better than you, or parts of the person's life better than you, or just might be having the more appropriate skills to support someone with communication difficulties. So examples may be social workers or care workers. A speech and language therapist might help. Would the client benefit from having someone else present, such as an interpreter, a sign language interpreter, a lip speaker, a deaf-blind communicator? Do your research before the meeting. Find out what helps the person to communicate and what doesn't help. You can do this by speaking to the client before the meeting, or someone such as a family member or carer. Gather information on whether the person might need support or adjustments in any of the attention, listening and looking, understanding the situation and others. So understanding verbal and non-verbal communication, expressing themselves, whether that's verbally or non-verbally, and social interaction, so eye contact, proximity. How would the client like to be communicated to? What tools can you use? What way can you enhance their ability to be able to give you clear instructions? Understand the person's injury or illness, how it may affect their decision-making process, and what some of the symptoms may be. You need to be mindful and may need to suggest another meeting or another day or location. So again, coming back to vulnerability, that anybody can be vulnerable at any point, and it might not be obvious that someone is. So, for example, if somebody is living with combat stress, they might appear to be ineffective and not have issues with decision making or communication. but you need to be aware of that. And I know you're not necessarily going to probe into everybody's personal circumstances, but if you're aware of that, then don't have a meeting in a loud room. Make sure the person can see the exit. Be mindful of loud noises or a feeling of being in a room that a person can't leave. Just be aware of that and how it might impact on the person's ability to make a decision. If they're sat there worrying how they're going to get out of the room in an emergency, or they're hearing loud bangs or sirens going on outside, they're not going to be able to properly concentrate and give you clear instructions. Check for any written recommendations. That might be a communication passport or an advanced care plan. Might get that particularly where there's a speech and language therapist involved or some specialist carers. And think about non-verbal communication strategies. So gestures, videos, pictures. What could you prepare in advance to help represent keywords or ideas? Do you already have, as a firm, some appropriate resources you could access? If not, look at websites that might be able to provide those for you. So at the meeting itself, understand the person. It helps you to build trust, understand their wishes and feelings, which could be a relevant factor if they lack capacity and a best interest decision needs to be made. It helps also to build a broader picture of the consistency and rationality of the client's answers. Be patient. You may need to have more than one meeting with the client in order to properly assess capacity or undue influence, or support them to be able to make a decision because of communication difficulties. Do not pressure your client to make a decision. And back to risk. Apply a risk-based approach. Is there a risk of challenge to capacity, for example, even if you feel the client has capacity? If there is, get a capacity assessment to protect yourself, protect the client. Try and do everything you can to be able to give effect to the wishes and the instructions that the client is getting. So the case of JKS and ADS and DSM, where Mr. Justice Charles provided guidance to those undertaking capacity assessments, but I'd extend this to supporting all clients, where he stated that you should consider seeing P in circumstances that would reduce family influences, such as a neutral venue, but at least not in the presence of those family members. The history they took and were given is balanced, applied with care and in a way that recognises the difference between fact and assertion. And the explanations, questions and prompts given to P were appropriately framed. For example, as to why P was expressing the views that he or she was and what P remembered about relevant parts of his or her family history. So in terms of questioning techniques, use simple language. About the 10th time I've said it. Use simple language. Use familiar words to the person. Tend to be words that are used in daily life, which are known as high frequency words. Avoid professional jargon or words that are less commonly used in everyday life, which are known as low frequency words. Use active sentences instead of passive sentences. Put the doer at the action at the start of the sentence. Avoid too many pronouns such as he, she, they, us, this, that. Use the person's name or title instead, for example, doctor. Avoid sentences with multiple parts. Try to make one point per sentence. Consider using different forms of communication such as pictures. Ask general questions, which helps to facilitate trust and rapport, but will also assist you when considering if your client is providing consistent and rational answers. Those questions can be a mixture of open and closed questions. And then come back to those questions as a way of checking the consistency and accuracy of what the client has given. At the beginning of the meeting, you open with, isn't it a lovely day and do you enjoy gardening? And the client says yes. It's really mundane, but you can spend a bit of time building that rapport, talking about gardening and what they enjoy and gardening tips or whatever it may be. But you can come back to that later on and say, do you like gardening? And okay, it doesn't mean the client has or hasn't got capacity, but if they suddenly say no, or they said at the beginning they were going to do something in the afternoon they're saying they're not, or when you come back to it they say they're not, it's a really easy way of checking memory, checking consistency, of checking understanding. Ask your client to confirm what their understanding of the purpose of the meeting is, and also confirm any instructions that are agreed or advice that has been given in a way that they're feeding back to you to give them their understanding of it. So one thing that we often see is that family members will contact you to arrange a meeting. They'll say, Mum or Dad wants to change their will, will you come and see them at home? And we've had instances in the past, which is why we now always make an effort to check it, where when the fee earner has turned up at the house to see the client has said, well, I didn't know why you're here, and I don't want to see you, and I don't want to change my will. It's a waste of everybody's time. It also helps you to understand that the advice you're giving is what the client wants and understands from their point of view as well. So as I've said earlier about identifying the relevant information and building your questions around it. So for example, if someone's going to sell their property, the relevant questions will be things like, what is the address of the property? When did you move there? What's the sale price? The person might not know that if they're in a care home, but some idea about what it's worth. What could you buy for, say, the £300,000 sale proceeds? Where are you going to live? If they're buying a replacement property and their excess sale proceeds, what's going to happen to those? You need to know the answers to as many of the questions that you're asking as possible. Don't just assume that because a client's answers appear rational or even irrational, doesn't mean that they're correct. Do the answers feel right? Sometimes gut instinct can be very powerful. And finally, what is the risk? Any doubt, get a capacity assessment or look to ways to mitigate that risk. Just briefly about attendance notes. So attendance notes are really, really important. Can't overstate it enough. So good attendance notes must include, but it's not limited to, the details of the client. So who they are, their address, any health conditions or injuries. Identify any vulnerabilities or adaptations that have been made, depending on what the instructions are, but details of assets and liabilities and how those assets are held. Details of the client's family and dependents. So in the context of making a will, if someone comes in and says, I want to leave my estate to my children, Bob and Ben, don't just assume there aren't any other children. Record the questions asked and the answers received, and this should be verbatim, using a Latin word, but exactly as they are given back to you wherever possible. Details of the advice actually given, who was present at the meeting. Ideally, the client is going to be seen alone for at least part of that meeting. The assessment of capacity, specifically ticking off, identifying the relevant law, the decision that's made, the legal test, and how each part of that test was satisfied. Don't ever say, oh, the client had capacity. Well, capacity to do what? How is that assessed? How have you ticked off the relevant legal framework and the relevant legal requirements as part of your assessment? Whether undue influence is a concern and how it's been addressed, and next steps. You should consider asking the client to sign a copy of the attendance note confirming it's an accurate reflection of the meeting, and you might also want to record the meeting, obviously only with the client's consent. So just a very brief case study, because I think this is an area that's not commonly accounted by us as practitioners. And sorry, that's an example of where someone has a hearing impairment. But the tips are relevant to many clients. As I said before, prepare properly. What are you going to ask? Do you need any special equipment or aids, such as a picture board or someone who can help with translation? Do not make assumptions. Not all people with a hearing impairment use sign language. Each will have their own preferred method of communication. That's particularly where someone has developed a hearing impairment. Find out what the client prepares before the meeting so that you're not faced with a panic of, I need to find someone who can assist with BSL, or I need a hearing loop. Try to ascertain how long the person has had the impairment for. So if it's recent, the client may not have yet adapted well, whereas someone living with a lifelong impairment should have developed better strategies. Make sure the space is well lit so that your face is visible and no background noise. Don't sit too close or too far away. Make sure the space and distance is comfortable for the client, so they may be lip reading and they therefore need to have a clear view of your face. If they're using a hearing aid, make sure it's connected to any loop system and the volume is comfortable. Look at the client when you're speaking. Use normal lip patterns, don't exaggerate words. Whilst you think it may help, it probably won't. Speak slightly slower than normal. Don't shout. Use short sentences. Use one topic per sentence. Avoid legal jargon, my favourite. Explain in simple terms. Keep meetings short or take regular breaks. Lip reading can be very tiring, especially if the client is trying to understand new concepts. Keep your mouth visible at all times, so don't cover it with your hand, or drink, or eat, and be patient and don't give up. So it's also worth noting that for historic educational reasons, many people with a learning impairment may not have received a good level of education in literary skills, and so their reading and writing skills may not match their intellectual ability. And also, if BSL is their native language, some of their written communication could appear jumbled due to the different grammar structures between the languages. If you're not sure, involve an expert. Okay, a few further reading notes. I'm not going to run through these, but they're there for reference. So 3 of them. And then finally, just in summary, anyone can be vulnerable at any time, and not all vulnerabilities are obvious. Don't make assumptions. Just because someone has a vulnerability, it does not mean that they cannot give instructions. Identify the decision to be made and the relevant legal framework. So I had an example recently of a client who had some quite odd delusions about their family. And whilst that would be relevant if I was taking instructions for a will, I was there supporting a colleague who will be acting in the sale of the client's property. Those delusions aren't relevant. So just be clear, what is the decision that needs to be made? Consider ways to support the client's decision making. You might need to be creative. Involve other professionals if needed. Keep detailed attendance notes. And if there's any doubt, instruct an expert. So I've got time for any questions, and then just briefly, if I just go to the next slide, it's got my email address on there as well. And because I can't see any of you, I'm going to give a quick brief shout out to a couple of books I've actually written. So one is about assessing capacity, and one is due out about it's an introduction to the court of protection, so common applications to the court, and hopefully that's got some quite practical resources in it. It will be available through Law Brief Publishing or Amazon. And that's enough about me. So I'm going to stop sharing my screen and see if we have any questions. I can't see any, but please feel free to raise some if you do. Oh, there's one there. Okay, I'm just going to read it out as it is. So it's from Paul. Say you have an elderly will client who you narrowly consider has capacity, perhaps with memory issues or difficulty with more complicated concepts, and who you have advised to obtain a formal capacity assessment from their GP, but who has declined to do so. How far would you push the issue? Appreciate the comment, if in doubt, get a capacity assessment, but I'm also mindful that the need not to discriminate against vulnerable clients and potentially at least double the bill for their will. The things that spring to mind are risk management. Who is going to help you if it turns out the will is overturned on the grounds of lacking capacity? The answer is no one. So protect yourself. So I'm very mindful about not protecting the client, but this is a webinar for practitioners, so protect yourself because no one else will. A GP is probably not appropriate anyway, and this is part of the issue because the proper capacity, or the person who is best equipped to provide that capacity assessment is going to charge a lot of money. They're experts, and that's what it is. So what is the risk with what is being suggested? If it is a minor amendment to a will leaving £100 legacy to the church, the client's local church, is that a massive risk if they lack capacity? Probably not. I'm not saying do it if you think the client lacks capacity, but in this situation you think that they do. Explain in your attendance notes why you think they do, and try and tick all of the boxes off for that, the applying the framework and Banks and Goodfellow, and all those requirements there, and considering key and the influence of grieving on someone's capacity. If the person doesn't make a will and the default position is the intestacy provisions, and that is what the will is saying, again, less risk, but you need to be satisfied the client's got capacity. If they're saying, I'm going to leave it all to one child, leaving someone else out, I would absolutely insist on a capacity assessment. It is matter specific, and I'd say there might be some situations where you don't, but that is where my starting point would be. It's not, wills are massively risky, and people don't appreciate that necessarily, and they feel that, you know, it's all very easy, you can do it for yourself for 20 quid and buying your WH Smith pack to do at home. But we are the ones that are carrying the risk, and it's really the risk is enhanced because the client will have died at the point this becomes an issue. You can't then ask them what do they think. You can't carry out a capacity assessment. So make sure there's a paper trail that protects you and protects the client. So if they're wanting to make a will, you need to do everything you can to ensure that those wishes are carried out as much as possible. So I hope that helps. But protect yourself. And I would be saying to the client, this is what's needed to help mitigate claims against your estate, which could amount to thousands and thousands and thousands of pounds. Your 500, 600,000 pounds that you're spending now, 2,000 pounds for getting a very specialist capacity assessment is nothing compared to what it could cost. Okay, anybody else?
Are there any other questions?
No, can't see any, but say drop me an email if anybody's got any subsequent questions.
Well, we'll give people a few minutes. I was just to say, thanks, Holly. That was fascinating for me. Key points for me were protect yourself. The stat about over 27 million people exhibiting potential vulnerability characteristics in the UK was staggering.
Scary, isn't it?
Yeah.
I mean, I don't know what the population is. It's like 60 or
60
million.
Yeah, 60
I mean,
million.
I don't know how that breaks down, but
yeah. And it's not always obvious. One person's definition of vulnerability is different to another's. Influence is also not obvious. Influence can be very, very well hidden. Don't assume anything. Try and understand the situation, and communication strategies are key. Yeah.
Actually, just coming back to the question that was raised, if you are preparing a will for a client, and it might be a fixed fee, but I mean, generally wills, straightforward wills will be a loss leader for some firms. Some firms won't act on that if that's going to be the situation. But let's say it is, having several meetings to assess clients' capacity and get their instructions and support them and everything else can be not financially viable, and people will not want to do it, and they'll be tempted to cut corners, but I'd say it will, there's a risk of it coming back on you. So I appreciate it's harder on those sort of smaller value matters than it might be if you've got an ongoing relationship with somebody, but you just need to use your judgment.
All right, thanks, Holly. I don't think there's any more questions, so I think just to advise people that will be sent a link to the recording of the session in the next few days, and also if there's any feedback on the session or the wider programme, send that to Helen Opie at surreylawsociety.org.uk. There's nothing further. Oh, there's one more question, I believe. Oh, comment from Karen, very helpful. I will be separating and devoting clients, many of whom are vulnerable. Excellent presentation. Thank you.
Yeah, you're welcome. And they will be vulnerable because they'll be it's a very difficult situation, and then trying to separate issues of capacity and undue influence and just hatred, and I'm a bit stereotypical, but you know, how that's impacting on a person's decision-making ability can be really difficult. But there's a principle of the Mental Capacity Act that says an unwise decision doesn't necessarily mean the person lacks capacity, and you probably come across that quite a lot in matrimonial clients. Thank you, everybody.
Yes, thank you all, and thank you, Holly, particularly.
No problem. Thank you.